Hello, Business Law 1. Welcome to class. I'd like to talk to you about the topic of legality, one of the elements to make an enforceable contract. The subject matter of the contract must be of a legal nature in order for it to be an enforceable contract. There are going to be two major areas that I want to talk about today. That is contracts that are contrary to statute and contracts that are contrary to public policy, which if are in violation, then the contracts are void. I would like you to notice there is a quiz in your PowerPoint that you can use just to kind of quiz yourself, sample questions to get you prepared for class, all on your own, not graded. All right, let's get into the subject matter at hand. Illegal contracts. These are contracts where both parties knowingly enter into illegal agreements. If they do, the court leaves the parties exactly where they find them. All right, so for example, if you're on the street and somebody approaches you to buy $10 worth of cocaine, all right, and you find out that they shorted you and they really didn't give you the amount, the right amount, and you go to the police to complain. One, the police are probably going to lock you up. Two, if you go to court, like a civil court, to try to get compensated for the shortage, the court is going to dismiss it, probably refer you to the police, but they're going to leave you exactly where you're at. There's no enforceability with contracts that are of illegal nature. Well, what I'd like to do is for you to take a quick look at other contracts contrary to statute, such as usury statutes where they charge too much interest. Those are unenforceable. Gambling statutes, if you lose in a poker game, those are unenforceable. Blue laws prohibit the sale of, for example, alcohol on Sunday in certain counties. All right, so those are contracts contrary to statute. But the one I want to spend most of the time on are licensing statutes, where the state requires you to have a license in order to perform either, for example, like cut somebody's hair or act as an attorney or as a doctor, where the state requires licenses for individuals to be able to perform certain activities. Well, it's a little bit of trickiness that I want to be able to describe to you so that you're successful on the exam. If an individual, let's say a lawyer, okay, who does not have a current license, practices law, does the client have to pay the fee if the individual does not have a current license? And the general rule is an unlicensed person cannot enforce a contract to provide services. Let me repeat that. The general rule is an unlicensed person cannot enforce a contract to provide services. There are exceptions, and we have to look at these two aspects. All right. That is, was the license, the attainment of the license, did the state pass it with a regulatory intent, or did the state pass the law that required the license as a revenue-raising intent? All right. See, if it's a regulatory intent, then the purpose behind the legislation was to protect the public. Okay, then the unlicensed persons cannot recover payment for services if they do not have a license. However, if the purpose of the legislature when they passed the law was just to raise revenues, okay, that's the way they created more revenue, was to require more people to get a license and then pay for the license. If the unlicensed person, okay, can establish that the state does not regulate them, but rather just raises revenues, then they are able to have contracts for services and enforce them, and they're still enforceable contracts. All right, so let's just kind of review that more quickly. When you have a situation where an individual needs a license because the state requires it, if the purpose was to regulate that individual to protect the general public, then any contracts they enter into, if they don't have a license, are not enforceable. However, if an individual enters into a contract and their license has lapsed, but the purpose of the license or the intent behind it was not to regulate, but rather to raise revenues, then if that individual entered into a contract, those contracts are enforceable. I'm repeating myself. Let's move on. The other category of contracts that may not be enforceable are contracts contrary to public policy. Okay, so let me give you an example. Some contracts between private parties are void. They're not enforceable because they're against public policy. For example, contracts to influence public officials, like bribes. Contracts to obstruct legal processes, like tampering with a jury. Contracts to commit a tort, like I contract with you to go punch that fellow student out. Okay, those are not enforceable. Contracts that restrain trade, okay, because the Constitution calls for the Commerce Clause, the free flow of commerce. So any contract that unreasonably restrains trade are unenforceable. Contracts for sexual favors, like prostitution, those are not enforceable. So the ones I want to zero in on are business related, contracts in restraint of trade. Let me read your outline for you. Contracts that tend to reduce competition for the provision of goods or services in one or more markets, or covenants not to compete. Those are all illegal. All right. As a general rule, contracts in restraint of trade or covenants not to compete are illegal. However, there are exceptions, and there are two main exceptions, and they have to do with, one, the sale of a business, or contracts for employment, or employment contracts. And I gave you in your outline two examples of that I want to talk through with you. All right. So I'm looking at right now the example of the sale of a business in the Deere Corporation, where they want to sell their business to the HI company. All right. They both produce big farm equipment, big construction equipment. Excuse me. Normally, a sale of a business is an exception to the rule if it meets these two key elements. All right? So, let me back up. Any contract that would unreasonably restrain trade would be void or voidable. All right? However, if it's a reasonable restraint of trade, then it would be permissible. The question is, what makes these sales of businesses reasonable? Well, it depends on two key elements. All right? And the two key elements are geographical limitation and the amount of time limitation. So as I describe in this case, in the Deere Corporation, these are a multinational, it's a global company. And so very large company, their market is the world, all right? So when it comes to geographical limitation, if it were to limit Deere Corporation from competing with High Corporation just within the United States, normally you would think that would be unreasonable. However, if their market is global, that tends to be a reasonable limitation, so long as the time limitation is reasonable. And let's see, what does the facts show? Let's read this together. Deere Corporation was engaged in the business of making and selling harvesting machines. It sold everything pertaining to its business to the High Company, agreeing not again to go into manufacture harvesting machines anywhere in the United States. The Deere Corporation, which had a national and international goodwill in its business, now begins to manufacture such machines contrary to its agreement, should the court stop it from doing so. Well, I think we already established that limiting the United States in a global market would be reasonable. However, there was no time stipulation, all right? It didn't say, for example, for 1 year, which would be reasonable. Maybe 2, 3, 4, maybe 5 years would be reasonable. But since there's no time limitation stated, that would be unreasonable. And so this contract would not be enforceable as a unreasonable restraint of trade for Deere Corporation to go back into the business. All right? The other example of an unreasonable restraint of trade involves employment contract. All right? And I know you can read this yourself, but it helps set the stage if I read this with you. So bear with me. Charlie Lee engaged in industrial laundry business in Central City and employed Tim Close. Previously, he was employed in the home laundry business as a route salesperson. Lee rents linen and industrial uniforms to commercial customers. The soiled linens and uniforms are picked up at a regular interval by the route drivers and replaced with clean ones. Every employee is assigned a list of customers who they service. The contract of employment stated that in consideration of being employed, on termination of their employment, Close would not directly or indirectly engage in the linen service supply business or any competitive business within Central City, Illinois, for a period of 1 year from the date when their employment under this contract ceases. On May 10th the following year, Close's employment was terminated by Lee for valid reasons. Close then accepted employment with Ajax Linen Service, a direct competitor of Lee in Central Service. He began soliciting former customers that he had called for with Lee and obtained some of them as customers for Ajax. Lee brings an action to enforce the provisions of the contract. Now, with employment contracts, we're looking at 3 key elements to make it reasonable. Is the geographical limitation reasonable? Is the time limitation reasonable? And then number 3, is it a reasonable infringement or not reasonable deprivation of a means of earning a living on behalf of the employee? All right. So when we analyze this case, the geographical limitation seems reasonable, just Central City. The amount of the time limitation seems reasonable, just 1 year. So it's the third element that we have to look at. Is the restriction on Tim, hang on just a second, is the restriction on the employee reasonable considering the size of this company and the geography that they're limiting it to? And what we see here, if we look at the language, the contract of employment stated that consideration of being employed. Okay, if he was terminated, Tim Close would not directly or indirectly engage in business within Central City. That sounds pretty reasonable. Mr. Close could take a job in some other town. He could be a truck driver for some other business. But what does he do instead? He takes a job with his former employer's competitor in this small town. So he's in violation of this restraint of trade, and this employment contract would be determined to be reasonable. All right. Unconscionable contracts are any contracts that the party possessed where there was severely unequal bargaining power between the two parties. If you see where there's a dominant party and a subordinate party, and the subordinate party has really no other choice but to deal with the dominant party, and the dominant party takes advantage of the subordinate party, the court may rule that this is an unconscionable contract and would not enforce it. All right. What are the effects of illegal contracts? Well, the court has a number of options. They can just void the entire contract, or they could cut out the part that they determine to be illegal, or if they determine that part just to be unconscionable, and they could leave the remainder of the contract enforceable. So they could either void the whole contract or just void the parts they don't like. All right, that's all we have for illegal contracts. If you have any questions, please be sure to get in touch with me. Thank you.